But rather than operating as a tax on income, this is a tax on the persons. All persons who cannot avail themselves to an exception, one of the exceptions being those who have actually purchased a qualified insurance plan, are subject to the tax, and it is therefore a capitation tax. Unlike income taxes, which under the 16th Amendment can be assessed without or disproportionately among the states, the Constitution requires that capitation or direct taxes be apportioned among the states on the basis of census population. Soon after the 16th Amendment, the Supreme Court acknowledged the continued constitutional requirement of apportionment of taxes imposed directly on the person, and I'll omit the quote because I'm out of time, but essentially the difficulty associated with apportionment was one of the reasons that we went and adopted the 16th Amendment in order to allow disproportionate taxation. In order for this to work, if Ohio has, I don't know what the percentage is of the state population, 7%, let's say that it's 7%, they would have to pay 7% of this particular tax. The difficulty associated with that is there's a number of exceptions to this, which are going to have a lumpy distribution across the country. Among the most problematic is illegal immigrants are exempted from the tax, which just, knowing that in fact there tend to be more illegal immigrants as a proportion of the population in, for instance, border states, that alone will skew the dynamic sufficiently to make it the tax apportionment unconstitutional. So with that, I'm out of time. I'll address any other issues in my rebuttal.
Good afternoon. It's always nice to be here at the Ohio State University College of Law. Constitutional law, that all of your best courses involve constitutional law issues. Of course, Constitutional Law 1, Constitutional Law 2 are the best courses taught in law school, correct? Everyone nods their head, yes. How many of you are taking constitutional law now or have had constitutional law? Okay, so it must be a second-year course, or we've got a lot of first-year students here. It will be your best course, trust me. Let's go back and look at Constitutional Law 1. Real quick, you go back to 1787. The framers get together in Philadelphia that hot summer, and by September hammer out this important document that does, in fact, as my colleague has pointed out, limit the powers of the federal government. Unlike the state governments, I must concede that the federal government has limited powers. And in fact, enumerated powers. Most of them are spelled out in Article 1, Section 8 of the Constitution. Article 1, in my mind, the most important provision in the Constitution of the United States. If you get that document out and look through it, they're pretty specific. The framers talk about coining money. They talk about establishing postal roads. They talk about regulating interstate commerce, among other things. The framers did not intend to give the federal government, the Congress, the general powers that were reserved to the states. Then you've got the 10th Amendment, which hammers that. Again, it makes it clear. Written in 1789 by James Madison, finally ratified by 1791, the 10th Amendment makes it clear that the states are the repositories of general powers, not the federal government. Congress, if you want to do it, you've got to link it to something in Article 1, Section 8. And you know what? For the first 100-plus years, Congress does not do much. What does it do? It establishes a national road running right here through Columbus. It socializes the waterways so that now navigable waters throughout the United States are freely accessible to us all. Yes, socialism was alive in the latter part of the 18th century, the early part of the 19th century. But that's about it. Congress just did not have a whole lot to do. Then comes the Industrial Revolution at the end of the 19th century, and what happens? Congress jumps in. Lots and lots of federal agencies created, right? You've got the alphabet soups out there. The Industrial Commerce Commission, the ICC, whatever it's called, the FEC, the FTC, all this, the SEC later, all this stuff comes out of the Congress. And the question raised before the Supreme Court is, can Congress do that? This is the latter part of the 19th century, the late 1800s, the early part of the 1900s. And the Supreme Court of the United States routinely strikes down these new congressional inventions. You know why? Coal mining is not commerce. Manufacturing is not commerce. Labor is not commerce. Child labor is not commerce. So Congress repeatedly loses under this definitional approach to commerce. The Supreme Court comes up with its own definitions. And it says these are not it. Instead, these are things that the states can regulate. But you know what? Because of the race to the bottom, the states weren't regulating them either. The fear in the states was if we regulate this stuff, oh my goodness, BFC, don't worry about the acronym, is going to move to West Virginia because they can't hire children here, right? All the corporations are going to move because Ohio is regulating. So the result was the Supreme Court said to Congress, you can't do it. The states wouldn't do it because it was not in their economic best interest. We had child labor. We had no regulation of mining. We had air pollution. We had water pollution. We had some major problems. And that's how it was in the early part of the 20th century. Because the Supreme Court stuck its ugly nose into America's economic problems, socioeconomic problems. And then what happens? Roosevelt threatens the Supreme Court, right? Roosevelt says, all right, I'm losing 5-4 in the Supreme Court, sometimes 6-3, but mainly 5-4. So here's what I'm going to do. I'm going to appoint 6 new justices, right? And then I'm going to win 10-5, easily. I get 1 justice for every justice on the court who's above the age of 70. And there were 6. Now, that's his court packing plan. And it goes to the Senate. And who knows what's going to happen in the Senate. Ultimately, the Senate voted it down. But in the interim, Owen Roberts changes his mind. That's the switch in time to save the 9. And the Supreme Court flips. And now, Roosevelt's winning 5-4, 6-3. And the Commerce Clause is dead, folks. It's dead. It's dead because it did not work as a juridically enforceable provision in the Constitution. So from 37 on, at least until 1995, the federal government can do what it wants under the commerce power. The federal government gets to define interstate commerce. Is that a good thing? Is it a bad thing? Lots of debate on that. You know what? Constitutionality is not a question of wisdom. And I tell my students that all the time. There are lots of dumb laws out there. There are lots of stupid provisions on the books. Stupidity does not equate with unconstitutionality. Just because it's dumb doesn't make it unconstitutional. So there are lots of laws passed after 37. I wouldn't pass them. You wouldn't pass them. They're stupid. The prohibition on marijuana possession, for example. But they're constitutional. That's all there is to it. Because the courts couldn't figure out what commerce meant. It doesn't work. We're a democracy, right? We're not supposed to be an oligarchy. So this is something best left to the political branches of government. That's what we discovered. That's what history teaches us. And now we're right back to that same point again, talking about ObamaCare. Is it wise? You got me. I don't happen to like the bill. I probably agree that it's stupid, maybe for a different reason. But does that make it unconstitutional? No. Is it commerce? Does it regulate commerce? Yes. The precedents make that clear. The precedents post-1937, with a couple of caveats. Case came out in 1995 called the Lopez case, the Gun-Free School Zone Act case. The Supreme Court 5-4 strikes down a federal law that makes it a crime to possess a handgun in a school or within 1,000 feet of a school. The Supreme Court says, we're not sure that gun moved in interstate commerce. Who knows? Maybe it's produced locally, local bullets, local kids getting killed. Who knows? It's local. Congress can't do that. That was 5-4, a very close decision. The Chief Justice, Rehnquist, wrote it. And the usual suspects on both sides, the 4 liberals, the 5 conservatives at the time, they've changed a bit. And the liberals have too. New makeup. We'll talk about that in a minute. But a very contentious decision. First time in almost 60 years that the court had used the Commerce Clause to strike down congressional legislation. Then comes in 2000 this Morrison case. It's the Violence Against Women Act case, the VAWA case. Congress makes it a crime to engage in domestic abuse. This was a horrible case that came out of Virginia Tech. It involved football players who raped a young woman on campus. She sued the football players under the Violence Against Women Act, this federal statute, and the Supreme Court 5-4 again strikes it down. Says, nope, you know what? We think domestic abuse starts to look a lot like marriage, and that kind of family law stuff should remain with the states. We don't see the connection between domestic abuse and interpersonal. So then, after 2000, all of a sudden we thought things had changed, and maybe we'd gone back to the early part of the 20th century, where the court is going to start substituting its judgment on interstate commerce for that of the majority, the Congress anyway. But you know what? It didn't happen. 5-4 was Morrison, as was Lopez. And then in 2005, something happens, changes everything. And that something is the Raich case, the marijuana case. Can the federal government regulate marijuana? This comes out of California. In California, a woman says, the dope I buy is all locally produced. The seeds are local, I'm not going anywhere. The smoke stays local. I'm somewhere in Sacramento, it's not going to cross state lines. It's all local. No interstate commerce. Congress, you can't regulate it. California has now legalized medicinal marijuana. So her possession doesn't violate California law. The feds want to go after her. Supreme Court, 6-3. This isn't that close. Kennedy and Scalia in the majority. Kennedy and Scalia, two conservatives who the Heritage Foundation has to rely upon. If they don't get Kennedy and Scalia, they're dead in the water. Nope. 6-3, Kennedy and Scalia, Congress can regulate it. Why? Drugs. Congress can regulate drugs. Drugs start to look a lot like health care. Okay, if that one's not convincing, here's the next one. Oregon against Gonzalez. 2006. Comes out of Oregon. Oregon starts to tell its doctors you can prescribe opiates, narcotics, to terminally ill patients to hasten death. Okay? The Bush administration, Bush 2 administration, doesn't like that. The Bush 2 administration changes its interpretations of federal regulations to prohibit the prescription of drugs to hasten death. The federal government licenses physicians who hand out the goodies. If you want narcotics, you can get them through your physician, but your physician has to have a federal license. The federal government, the AG, says to these physicians, if you start handing out these narcotics to hasten death, we're going to pull your license, which pretty much puts you out of business. So the federal government is jumping in to regulate the distribution of drugs. Healthcare, it's all healthcare. Case goes to the Supreme Court. The Supreme Court in this one rules in favor of Oregon. It says that the Bush administration has misinterpreted the federal regulations. So the federal government loses, really, as a statutory matter. But you know what? All 9 justices agree. The federal government could have done it if the regs were right and if the statute were correctly read. Could do it. Even Thomas, in dissent, says, I'm dissenting, but it's not about the Constitution. Clearly, Congress could do it. Even he says Congress has the commerce power to do it. So you put the Oregon case together with the Raich case, together with all that precedent that antedates Lopez and Morrison, and it's clear. Congress can regulate health. Congress can regulate the health industry. Congress can regulate medicine. It can regulate drug distribution. And that's just a small step from what you find with Obamacare. So I don't think it's going to even be close. If you got Scalia and Kennedy, that makes 6 votes with the current Supreme Court. I'm out of time. I'll talk about those individual justices in a minute. But I think pretty clearly Congress has the commerce power under the existing Supreme Court precedents.